Unit 4, Review Question Audio. Generally, separate property is anything you earned or owned, or a debt, from before you married or after you separated, anything you buy with separate property or you earn from separate property, gifts or inheritance, to one of you, even if it was given or inherited when you were married. What is meant by separate property? Separate property is property that is owned by one spouse and not the other. There are two categories of marital property: community property, and separate property. Community property is when spouses share all property equally. What are examples of separate property? Separate property is generally determined by the following rules. Property owned by one spouse before marriage is separate property. An example might be a car owned by you before you got married. Property gifted to or inherited by one spouse before or during the marriage is separate. Can husband and wife have separate properties? A married couple who live together are only allowed one main residence for tax purposes between them. After separation, each spouse is allowed their own main residence. The same rules apply to civil partners. When spouses own property together, it is called tenancy by entirety, TBE, is a way for married couples to hold equal interest in a property as well as survivorship rights, which keep their property out of probate. It's not 50-50 ownership. With TBE, each spouse owns 100% of the property. In a community property state, such as California, any income, real estate, or other property acquired by either spouse during the marriage belongs to both spouses. Under community property laws, both spouses own everything equally, regardless of who purchased it or earned the income. What is the opposite of community property? The opposite of community property, or community property law, is common law. The theory behind common law is that every individual, regardless of their marital status, is a separate being with their own legal and property rights. For this reason, individuals under common law are treated differently and separately than their spouse. Which of the following would be considered community property? Any real or personal property acquired with income earned during the marriage. This includes vehicles, homes, furniture, appliances and luxury items. Any debts acquired during the marriage. What is excluded from marriage and community of property? The only asset that may be excluded from the joint estate is an inheritance. How does community of property work? A marriage in a community of property is a type of marital regime where the spouses elect to have only one estate, and all assets and liabilities are equally shared. Usually, when a person gets married in a community of property, the spouses automatically become co-owners of all their combined assets. Does a will override community property in California? Even if a will or trust does not provide for a surviving spouse, the spouse, as long as they qualify as an omitted spouse, is entitled to whatever they would otherwise receive under California's laws of intestacy, which generally includes all the decedent's community property and all or portion of the decedent's. What happens when one spouse dies on community of property? If you were married in community of property, which is the default way for a civil marriage, then the house belongs to the joint estate between husband and wife. This means that when your spouse passes away, the surviving spouse is automatically entitled to a 50% share of the house. Eminent domain refers to the process by which the government may seize private property with proper compensation, but without the owner's consent. Let's say a city wants to widen an existing road. To do this, the city government can use eminent domain to claim 10 feet at the front of a commercial property. What are the 3 requirements for eminent domain? The eminent domain power is subjected to certain constitutional limits, such as, the property acquired must be taken for a public use, the state must pay just compensation in exchange for the property, no person must be deprived of his, her property without due process of law. What is eminent domain, and give an example? Eminent domain refers to the power of the government to take private land for public use under certain circumstances. For example, the government may sometimes take someone's house to make room for a new highway or bridge. California adverse possession laws require at least 5 years of possession and payment of taxes throughout that period in order to be eligible for legal title. What are the 5 requirements for adverse possession in California? In order to establish a title through adverse possession, all of the following 5 requirements must be satisfied. Claim of right or color of title. Possession must be held under either a claim of right or color of title. actual, open and notorious, hostile, continuous possession, pay all taxes levied. Common examples of adverse possession include continuous use of a private road or driveway or agricultural development of an unused parcel of land. Can you sell a house with adverse possession? How is this relevant to me? Adverse possession can interfere with the process of selling your land. This is particularly so where discrepancies between the boundaries shown by the legal title and the physical land that the seller occupies are only discovered at the 11th hour. What is foreclosure in simple terms? A foreclosure is the legal process where your mortgage company obtains ownership of your home, that is, repossess the property. A foreclosure occurs when the homeowner has failed to make payments and has defaulted or violated the terms of their mortgage loan. What is an example of foreclosure? When a homeowner stops paying on a loan used to purchase a home, the home is deemed to be in foreclosure. What this ultimately means is that the ownership of the home switches from the homeowner to the bank or lender that provided the loan. Intestate succession is the term to describe the process for handling an individual's estate when that person dies without a last will and testament. It is how the state determines who is to inherit what from you if you pass away. What is the meaning of intestate succession? Intestate succession. Noun. The distribution when a person dies without leaving a valid will and the spouse and heirs will take, receive the possessions, by the laws of descent and distribution and marital rights in the estate which may apply to a surviving spouse. What is the difference between an estate and a succession? Answer. The succession is the legal process of transferring assets to the heirs after death. Sometimes there is a will and many times there is not. The estate plan is putting in place a plan to protect all of your property and other assets and distribute them long term to those whom you desire to receive them. What is it called when someone dies without an estate? In the legal world, if you die without a will, it's called dying intestate. A local probate court then has to decide how to distribute your property. How do you divide intestate property? If the dead did not leave a will, intestate proceeding, the estate will be split equally among the surviving spouse and legitimate children. If there are illegitimate children, they are entitled to a portion equal to 1/12 of the share of legal children. Probate means that there is a court case that deals with deciding if a will exists and is valid, figuring out who are the decedent's heirs or beneficiaries, figuring out how much the decedent's property is worth, taking care of the decedent's financial responsibilities. Probate is the analysis and transfer administration of estate assets previously owned by a deceased person. Probate is a court process through which a decedent's estate is executed. First, the court will verify the decedent's will. A probate sale can occur when the original homeowner dies without a will or without any heirs to claim the property. Basically, it means that the homeowner died without a will bequeathing the house to an heir. Avulsion refers to water quickly submerging land or moving land to another location. In most situations under state property law, land moved by avulsion continues to be the property of the owner of where the land originally was located. What is the difference between avulsion and accretion? Avulsion is the pushing back of the shoreline by sudden, violent action of the elements, perceptible while in progress. Accretion is the process of growth or enlargement by a gradual buildup. Alluvial means an increase in land from the flow of water against a shore or bank. What is the difference between erosion and avulsion? Erosion refers to the gradual washing away of land bordering a body of water. Avulsion, however, is the process whereby there is a sudden and perceptible loss of or addition to riparian land or a sudden change in the bed or course of a stream. What is the difference between accretion and avulsion? Property law. In real property law, avulsion refers to a sudden loss of land, which results from the action of water. It differs from accretion, which describes a gradual addition to land resulting from the action of water. What is an example of avulsion in real estate? Avulsion may result in the addition or removal of land from a bank or shoreline. Let's look at an example. Anne owns a parcel of land along a bank of a river, and a violent storm washes away Anne's bank and deposits much of the soil a mile downstream onto Thames riverbank. What is the difference between avulsion and erosion? Real estate, the opposite of accretion. Erosion is the gradual washing away of land along the shoreline. However, the sudden and often very perceptible change to a shoreline by natural forces is referred to as avulsion. What is an alluvion in real estate? Primary tabs. Alluvion refers to the slow accretion or erosion of soil, sand, and other parts of land. Avulsion are the sudden removal of land of one owner and depositing on the land of another when a stream changes its channel. What is a grant deed? A grant deed, also known as a special or limited warranty deed, is a legal document used to transfer real estate between a previous owner, the grantor, and a new owner, the grantee. What does grant deed mean? A grant deed is used to transfer ownership of real property, often in conjunction with tax or foreclosure sales. It offers more protection to the buyer than a quitclaim deed but less than a general warranty deed. Is a grant deed the same as a mortgage? Grant deeds are not the same as a mortgage. Grant deeds, and other types of deeds, are used to transfer real estate ownership from a seller to a buyer. On the other hand, a mortgage is a conditional transfer or pledge of real estate as security, collateral, for the payment of a debt. What is another name for grant deed? A grant deed, also known in many states as a limited warranty deed or a special warranty deed, gives the grantee some, but not all, of the assurances of a general warranty deed. What is the difference between a grant deed and a quitclaim? In California, quitclaim deeds are commonly used between spouses, relatives, or if a property owner is transferring his or her property into his or her trust. A grant deed is commonly used in most arm's-length real estate transactions not involving family members or spouses. What is the strongest form of deed? A warranty deed is the strongest deed and warrants to the grantee that the grantor has not previously conveyed the estate or any interest therein to anyone except the grantee and the estate is free from encumbrances. Which type of deed offers the grantee the most protection? General warranty deeds give the grantee the most protection. Special warranty deeds give the grantee more limited protection, and a quitclaim deed gives the grantee the least protection under the law. What does it mean to be a grantor? The grantor is the seller, on deeds, or borrower, on mortgages. The grantor is usually the one who signed the document. What is the difference between a deed and a grant deed in California? Both types of legal documents serve the same function of transferring ownership of real property. The fundamental difference between quitclaim deeds and grant deeds is the level of protection and warranty provided to the grantee. What are the two main types of deeds to transfer property in California? California mainly uses two types of deeds, the grant deed and the quitclaim deed. What is the difference between a grant deed and a deed of trust in California? A grant deed is a transaction between two people or entities without securing the property as collateral. A deed of trust is used by mortgage companies when a homeowner takes out a loan against the property. What is the weakest deed? A quitclaim deed provides the least protection for the buyer, and its uses are very limited. This type of deed simply transfers any interest the grantor might have in the property. It doesn't guarantee that the grantor has any interest to convey. Which is more important, title or deed? Both the title and the deed are of equal importance because they both have a purpose in the home selling process. For instance, a title search can not only confirm who owns the property, but also lists any liens, loans, or property taxes due. The deed specifies who owns the property and to what extent. What is the best deed for a buyer? General warranty deed. General warranty deed. It's the type of deed that offers the most buyer protection. When committing to a general warranty deed, the seller is promising there are no liens against the property, and if there were, the seller would compensate the buyer for those claims. What is a quitclaim deed? A quitclaim deed is a document in which a grantor disclaims all interest in a parcel of real property and then conveys that interest to a grantee. Unlike grantors in other types of deeds, the quitclaim grantor does not promise that their interest in the property is actually valid. When is it appropriate to use a quitclaim deed? Quitclaim deeds lack certain protections and promises found in other types of deed to real property. Because of this, they should only be used under certain circumstances. These include transferring real estate between close family members, for example, from a parent to a child. What would a quitclaim deed commonly be used for? Quitclaim deeds, therefore, are commonly used to transfer property within a family, such as from a parent to an adult child, between siblings, or when a property owner gets married and wants to add their spouse to the title. Married couples who own a home together and later divorce also use quitclaim deeds. A deed of trust, also called a trust deed, is the functional equivalent of a mortgage. It does not transfer the ownership of real property, as the typical deed does. Like a mortgage, a trust deed makes a piece of real property security, collateral, for a loan. What is trust deed in simple definition? A deed of trust is an agreement between a home buyer and a lender at the closing of a property. The agreement states that the home buyer will repay the home loan and the mortgage lender will hold the property's legal title until the loan is paid in full. What does a trust deed do? What is a trust deed? A trust deed is a voluntary agreement between you and the people you owe money to, also called your creditors. You agree to pay a regular amount of money towards your debts, and at the end of a fixed time the rest of your debts will be written off. Is a mortgage deed the same as a deed of trust? A deed of trust is a legal agreement that's similar to a mortgage, which is used in real estate transactions, whereas a mortgage only involves the lender and a borrower. A deed of trust adds a neutral third party that holds rights to the real estate until the loan is paid or the borrower defaults. What is the difference between deed of trust and deed? Both the warranty deed and deed of trust are used to transfer the title of a property from one person to another. However, the difference between these two contracts is who is protected. As you now know, a deed of trust protects the beneficiary, lender. A warranty deed, on the other hand, protects the property owner. Why is it called a deed of trust? A mortgage involves only two parties, the borrower and the lender. A deed of trust adds an additional party, a trustee, that holds the home's title until the loan is repaid. Who holds the security in a deed of trust? For a deed of trust, the parties involved are the lender, the borrower, and a neutral third party who will serve as a trustee. The title of the property is held as security for the loan and held by the trustee for the benefit of the lender. The title is released from the trust once the loan is paid. When you transfer title with a gift deed, that's a declaration that you're doing out of love and affection, for absolutely zero consideration. In California, you can use either a grant deed or a quitclaim deed to gift property into someone else's name. What is the meaning of deed of gift? A legal agreement to give land or property to someone without charging them any money. My parents want to pass their house on to me as a deed of gift. What is the difference between gift deed and grant deed? Gift deed. A gift deed is a special type of grant deed that gifts ownership of real property interest to another person or entity. This deed is different from a standard grant deed because it specifically designates that the transfer was not subject to a sale, and the grantor received no monetary compensation. Is it better to gift or inherit property? Capital gains tax considerations. It's generally better to receive real estate as an inheritance rather than as an outright gift because of capital gains implications. That's because of cost basis, which is cost of the property used to determine the capital gain, if any, when it is transferred. How do I transfer property to a family member? In order to transfer property to a family member as a gift, you'll need to execute a deed of gift. This is also known as a transfer of gift. This legal process ends with the family members classified as the property's legal proprietors. A deed of reconveyance is a legal document that indicates the transfer of a property's title from lender to borrower, legally referred to as the trust or a deed of trust states. The deed of reconveyance is typically issued after the borrower has paid off their mortgage in full. What is the difference between deed of trust and deed of reconveyance? A deed of reconveyance is documentation that the debt secured by a deed of trust, a document that allows a third party to hold the title to a property until it is completely paid for, has been fully paid. What is an example of a reconveyance deed? As an example, say Sally decides to purchase a house, and in doing so, she needs to take out a mortgage of $300,000 from the bank. The new property acts as collateral under the deed of trust. Once Sally has fully paid off her mortgage, the trustee must then complete a request for reconveyance. What's the difference between conveyance and reconveyance? Conveyance transfers ownership of property from one entity to another. A deed is an instrument of conveyance, describing the parties and the property being transferred. A lender who holds title to the property must issue a deed of reconveyance to transfer the property title to the borrower. What happens to the title when you pay off your mortgage? Over the time you repaid your mortgage, you legally own the property, but the lender held the mortgage lien, or claim, to it. Now that you've paid back the loan, the lender needs to remove the lien, and to do that, it'll issue the deed of reconveyance. What is the purpose of a deed of reconveyance? A deed of reconveyance is a legal document that indicates the transfer of a property's title from lender to borrower, legally referred to as the trust, or a deed of trust states. The deed of reconveyance is typically issued after the borrower has paid off their mortgage in full. A sheriff's deed is a deed given to a party on the foreclosure of property, levied under a judgment for foreclosure on a mortgage or of a money judgment against the owner of the property. A sheriff's deed is used to transfer property to the highest bidder at a court-ordered foreclosure sale. The sheriff's deed conveys the ownership rights of the property to the winner of the foreclosure auction. The definition of a testator in real estate is an individual who makes or leaves a valid will detailing how their possessions are to be divided or distributed among their heirs. The testator can refer to anyone, regardless of whether the person is living or dead, so long as their will is valid. What is the definition of a testator? Definition of testator, noun. One who makes and executes a last will and testament. For example, if Tiffany has a will drafted and she executes the will, then Tiffany is referred to as the testator. Is a testator a person who makes a will? Who is a testator? A person who has written and executed a will, or any other person who makes a will is referred to as a testator of a will. A will comes into effect at the time of or after the death of the testator. After creating a will, a testator must sign the will along with the signatures of two witnesses. What does signed by the testator mean? Testator is the legal term for a person who makes a will. While the term rarely comes up in casual conversation, you'll still find it used in will documents and in the law itself. For example, the signature clause of a will might state, "I, Jacqueline Smith, the testator, sign my name to this instrument." What is the difference between a testator and executor? The person creating his or her will is known as the testator. A testator names an executor in his or her will. The executor has a legal duty to administer the testator's estate, making sure that the beneficiaries receive the assets of the estate, according to the will. What is the will owner called? Testator. The testator is the person who is making the will and signing his or her name. If the person making the will is female, the word testatrix is sometimes used. Beneficiary. A beneficiary is someone who receives an inheritance through a will. An executor of an estate is responsible for carrying out the wishes of the deceased. The executor has a fiduciary duty to act in the estate's and its beneficiaries' best interests. What is the legal definition of executor? An executor is someone named in a will as the person who will carry out the testator's formal wishes. Typical duties of an executor include paying outstanding taxes, debt, and distributing any remaining assets among the testator's heirs. Historically speaking, a devisee is someone who receives real property, as opposed to personal property, from an estate. In modern times, though, a devisee usually refers to anyone who receives property by being named in a decedent's will, whether they are related or not, like a friend, as described above. What is the difference between an heir and a devisee? Heirs are generally related to a decedent by blood, adoption, or marriage. By contrast, a devisee can receive property from a decedent simply by being designated in the decedent's will and does not necessarily have to be related to the decedent. A devisee is typically someone who receives real property, the devise, through a will. Real property includes real estate and land. A holographic will is a will signed by the testator, with its material provisions appearing in the testator's handwriting. The term testator means the person writing the will. What is the meaning of the word intestate? Of dying without a will. Primary tabs. Intestacy is the state of dying without a will. If a person dies without a will, he is said to have died intestate. The estate of a person who has died intestate goes through probate court. Administratrix is the outdated term used to refer to women that are court appointed to oversee the administration of estates for those that pass intestate. In the modern context, administrator is used to refer to all genders and may refer to a court-appointed administrator or executor of an estate. What is the difference between an administratrix and an executor? If a person dies leaving a valid will, and the will names a person who is to execute the will and administer the estate, this person is called an executor. However, when the person in charge of administering the estate is not named in a will, that person is called an administrator. What is an executor versus administrator versus trustee? A trustee is the person in charge of a trust. An administrator is the person appointed by the probate court to oversee a decedent's estate when there is no will. An executor is the person appointed by the probate court to oversee a decedent's estate when the will has been admitted to probate. The term accretion is used in real estate law to refer to an increase of land due to the accumulation of soil on the shoreline of a lake. What is an example of accretion real estate? Examples of real estate accretion. In 10 years, the wind moves a part of John's land on the George's property. In conclusion, George's property area will increase, because the land which was moved from John's surface, in his surface, will be his now. What is the difference between accession and accretion in real estate? Accession, an addition to property through the efforts of man or by natural forces. Accretion, accession by natural forces, for example, alluvium. What is the difference between accretion and avulsion in real estate? In real property law, avulsion refers to a sudden loss of land, which results from the action of water. It differs from accretion, which describes a gradual addition to land resulting from the action of water. What is the opposite of accretion in real estate? The opposite of accretion, erosion, is the gradual washing away of land along the shoreline. However, the sudden and often very perceptible change to a shoreline by natural forces is referred to as avulsion. What is the result of accretion? Accretion means an increase in land area due to the permanent retreat of the high water mark of a waterfront property. It also means an increase in property size as a result of the depositing of soil from a river, stream, or sea. Avulsion refers to water quickly submerging land or moving land to another location. In most situations under state property law, land moved by avulsion continues to be the property of the owner of where the land originally was located. What is the difference between erosion and avulsion? Erosion refers to the gradual washing away of land bordering a body of water. Avulsion, however, is the process whereby there is a sudden and perceptible loss of or addition to riparian land or a sudden change in the bed or course of a stream. What is the difference between accretion and avulsion property law? In real property law, avulsion refers to a sudden loss of land, which results from the action of water. It differs from accretion, which describes a gradual addition to land resulting from the action of water. The increase in land caused by the gradual recession, shrinkage, or change in course of a body of water, such as a lake, sea, or river, which gives the owner of the riparian property more dry land. Reliction is classified as a type of a riparian right. What is the difference between accretion and reliction real estate? Accretion is the process of growth or enlargement by a gradual buildup. Alluvial means an increase in land from the flow of water against a shore or bank. Littoral means a part of a river, lake or sea that is close to the land. Reliction is the gradual recession of water leaving land permanently uncovered. What is the opposite of reliction? Reliction in real estate is the opposite of the accretion in real estate. This process may refer to a change to the land surface, after the action of the water. Color of title refers to a document or other instrument that appears to be a legitimate claim of title to a piece of land, but due to a title defect, cannot transfer or convey ownership. What is color of title in real estate equivalent? What is a color of title? Refers to a claim founded on a written instrument, deed or will, unknown to the claimant is defective and invalid. The grantee without knowledge of the defect takes possession under color of title. In California, an easement is defined as a right granted to an entity to use a piece of property belonging to a separate individual or entity for a specific purpose. The most common types of easements in real estate are those that grant road or utility access. What is an easement in simple terms? An easement is the grant of a non-possessory property interest that provides the easement holder permission to use another person's land. What is an example of an easement? A common example of an easement is when one person is given the right to cross or access a road across another person's property. Other common examples of easements are phone, gas, and power lines. What is an easement around a property? An easement is a real estate ownership right, an encumbrance on the title, granted to an individual or entity to make a limited, but typically indefinite, use of the land of another. It is not a right of occupancy as such or a right to profit from the land. What is the most common type of easement? Affirmative easements are the most common. They allow privileged use of land owned by others. Negative easements are more restrictive. They limit how land is used. Is an easement a legal right? An easement gives the dominant owner the right or rights to cross or otherwise use someone else's land. Two of the most common easement rights are a right to light and a right of way. Is an easement the same as ingress and egress? Owners, particularly landowners in rural areas, often require an easement to access their land. In other words, without an easement, many parcels would be landlocked. Easement for ingress and egress is a fancy way of saying that an easement allows someone to travel to and from the land. A partition action is a legal action filed in court that names all parties who have or claim an interest in the subject property, including owners, lien holders, lenders, and holders of future estates. The action commences with the filing of a partition complaint, which is filed and served on all named defendants. What is the purpose of a partition action? A partition action is a lawsuit that forces the sale of ownership in court. Whether it's a building, home, or farm, anything attached to real property can be divided and sold by co-ownership in California. What is an example of partition action? For example, if a brother and sister jointly own inherited property from their parents, they might agree to a partition by appraisal. In that instance, they agree in advance that one of them would buy the other's interest at whatever the appraised price is determined to be. Which of the following defines a partition action? Partition actions are when one party to jointly own property or a business wants to sell their ownership rights. Business litigation and partnership disputes happen all the time, and the remedy is a partition action that occurs in a court of law. Parties owning property usually sell the property. What happens if one person wants to sell and the other doesn't? Do both owners have to sign to sell a house? No, all of the co-owners are not required to sell a house in California. Instead, a partition action asks a judge to sign for all co-owners, thereby ensuring that co-owners are not held hostage in a failed co-ownership. What happens to property after partition? After the partition deed is executed, each co-owner becomes the absolute owner of their share of the property, and they can dispose of the property as they wanted to. This means that they can sell, transfer, or gift it to anyone as they want. What is the power of sale in real estate? The power of sale clause in a mortgage note states that the lender has the power to sell the property in the case of a homeowner's default. In other words, it gives your lender the right to sell your home and use the proceeds to pay your outstanding balance if you fail to pay your mortgage. What is an example of power of sale? This means that if a borrower loses a property and the lender sells it, the borrower can't be held liable for costs not covered in the sale. For example, if a lender sells a foreclosed property for $60,000, but there was $80,000 of debt, the borrower can't be forced to pay the $20,000 difference. What is power of sale also known as? Power of sale foreclosures are also known as non-judicial foreclosures. Where is the power of sale clause found? A power of sale clause is included in most deed of trust mortgages. It lets a trustee proceed with a non-judicial foreclosure if you default on mortgage payments. In short, this enables foreclosure without going to court. What is the difference between power of sale and foreclosure? In power of sale, the lender sells the property. In foreclosure, the lender takes title of the property. In power of sale, the former homeowner gets the excess profits from the sale of the property. In foreclosure, the former homeowner gets nothing. Is power of sale also known as a foreclosure? With a power of sale foreclosure, also called a non-judicial foreclosure, the lender can foreclose without court oversight. In a judicial foreclosure, on the other hand, the lender forecloses through the state court system. What is the meaning of writ of execution? A writ of execution is a process issued by the court directing the U.S. Marshal to enforce and satisfy a judgment for payment of money. What is an example of writ of execution? A writ of execution can also be used to evict a tenant who will not leave on their own and who will not pay rent. In the event of a tenant's eviction, the issuance of a writ of execution allows the tenant and their belongings to be removed from the residence. What is a writ of execution on real property in California? The writ authorizes the sheriff to levy on specific real property and initiates the process for the sheriff to sell the property at auction. The proceeds would be credited toward the satisfaction of the money judgment. A real estate deed will become effective between the parties involved when it is delivered from the grantor to the grantee. If a deed is in writing, notarized, given to the grantee, and then recorded in the proper county, It will be presumed that the delivery was made with intent to transfer. What is the meaning of chain of title? Chain of title is the historical record of ownership transfers of a specific piece of property. The chain of title is imperative to establishing legal ownership of real estate, vehicles, patents, and other tangible and intangible property. What best describes chain of title? Chain of title is often described as the sequence of historical transfers of title to a property from the current owner all the way back to the original owner. This also applies to land without a home on it. A chain of title should always reflect continuous, unbroken ownership. What is the difference between a chain of title and an abstract of title? Similar to an abstract, a chain of title acts as a history of a property's ownership throughout the years, such as who previously owned it and when. Unlike an abstract of title, it's not a physical document, but a general history of the property and how its title has passed from owner to owner. What represents a legal title of ownership? A legal title refers to the responsibilities and duties the owner has in maintaining, using, and controlling a property. Legal title is the actual ownership of the property, the documented name of the property owner, as visible through the public records, typically describes the person with legal title. What's the difference between legal and equitable title? The legal title of a property refers to the legal ownership which comes with the right to control the property in compliance with the law. An equitable title gives a person the right to enjoy the benefits that come with the ownership of a property despite them not being the legal title holders. Is deed and title the same thing? When you own a home, the deed is the physical document that proves ownership. The title is the concept of legal ownership that the deed grants you. You can think of the deed as the document that transfers, or passes on, the title or the right to ownership.